Contradict case item 65, second appeal 92 of 2024.
Coming to the substantial question of law, you would kindly have this judgment that limitation under Articles 59 of the Limitation Act would not apply, rather 65 of the Limitation Act would apply, which prevents 6 to 12 years. Now to put a flag over it, number 38. Say when accepted on this, I do not have any question. Lord, reading para number 38.
Just read the facts.
Yes. Now para number 5 then, prayer and kindly you see. Prayer in the plaint. Para number 5. This is a suit was dismissed, appeal was the suit was dismissed, appeal allowed, confirmed second appeal, appeal not SFP Supreme Court confirmed. The plaintiff instituted a civil suit number 7 1984. That should put a mark 1984 in the court of so and so for permanent injunction, restraining the defendant from interfering with their peaceful possession to the extent of 1/3 share in the agricultural land and measuring 31 canals 14 miles situated in so and so. In the alternative, the plaintiff has prayed that they may be put to joint possession along with defendant and the sale deed dated 14/6/1973 purported to have been executed by so and so, and the plaintiff in favor of the defendant be declared fraudulent, concocted, and thereby void insofar as share of the plaintiff is concerned. Now, we will kindly take para number 9. Yes. Lord suit was in 1984. Para 9. All the above referred issues framed by the trial court came to be answered against plaintiff, ultimately came to be dismissed by judgment dated so and so. Para number 10. The plaintiff being dissatisfied with the judgment and decree passed by the trial court referred on appeal before the district court. First appeal came to be registered at so and so. The first appeal came to be allowed. The suit of the plaintiff was decreed on the point of question of limitation. The first appeal observed thus. Rachna, kindly read this paragraph.
Yes.
Lastly, the question of limitation has been raised in the present proceeding. As per the defendant, the present suit should have been filed within 3 years from the sanction of the limitation. He mainly relies on so and so, the state of Punjab so and so, which lays down that illegal and void order have to be got set aside from the court of competent jurisdiction and limitation for the same 3 years from the date of passing of the order. On the other hand, learned counsel for the plaintiff appellant has relied upon Article 65 in order to insert that the period of limitation shall be 12 years for getting the relief of possession from the date when the possession of the defendant would be deemed to be possessed to the plaintiff. Accordingly, he argued that even if it is presumed that the defendant came into adverse possession from the date of execution of the present sale deed, even then the plaintiff was entitled to get the relief of possession within a period of 12 years and the suit was filed within that period. Merely because it was filed after 11 years cannot deprive the plaintiff from the relief. The said argument of the plaintiff appellant is convincing. Since the claimed relief is joint possession, it has already been held that transaction in question was void and Raisel had never executed the sale deed in question. So, under the circumstances, the plaintiff could have maintained the action of possession of the property within the period of 12 years from the date of knowledge. So, even if the knowledge of the party is ignored, still the suit is filed within a period of 12 years from the date of the sale deed. The same is maintainable. My lord, thereafter, my lord, the defendants prefer an appeal before the High Court in the second appeal. My lord, the second appeal was allowed. My lord, I am reading para number 12 also. Previously. The High Court, by its impugned judgment and order, dismissed the appeal and thereby affirmed the judgment of the first appellate court, decreeing the suit in favor of plaintiff. However, insofar as issue of limitation is concerned, the High Court differed with the first appellate court and came to the conclusion that it is Article 59 of the Limitation Act and not Article 60, it should be 65. 63 mentioned. That would apply in the matter of fact. Now, let straight away come to para number 30. Lord should kindly take para number 21 also, the argument before the Supreme Court. Para number 21. it is argued that it is settled law that when the instrument of sale of immovable property is not executed by the owner, then such deed need not be void ab initio and considered as nullity qua the owner.
Then such a sale deed is void ab initio.
Then such
Is
a
not
sale is not
executed by the owner.
If not executed by the owner,
Owner.
it is void ab initio. And then it is considered to be a nullity qua owner. In such a case, the owner is not required to seek a cancellation of such instrument or seek a declaration that such instrument is void. This is the
Even
reason.
both the reliefs are not required. Neither cancellation is required, nor there is any requirement to seek that it is void.
Yes.
There is no need to seek any
Yes.
declaration because the owner did not have the title. He could not have passed a
So if
better
someone
title than what he
If
has.
I am not the executant and someone else is the executant will not, then he is not required to.
This particular paragraph
Yes.
is saying that the deed need not be challenged at all.
Yes. Void instrument not required to be challenged.
Void.
Yes. Yes.
If the owner did not have the title, right, was not executed by the
Yes.
owner. Somebody, instead of me, somebody else and goes and executes
Yes.
the sale deed.
Impersonation.
Impersonation,
Yes.
then there is no need for specific challenge in the matter.
Yes.
It is void.
Yes. Lord, your Lordship was saying the claim seal judgment also not. You are reading further. In such a case, the owner is not required to seek for cancellation of the instrument or seek a declaration that such instrument is void. This is the reason why the plaintiff has not sought for cancellation of the sale deed dated 1973 in the present case, and therefore there rises a question of the application of the Article 59 of the Limitation Act. No question of limitation, application of Article 59 of the Limitation Act 1863. The Council has placed lines on several decisions to emphasize that when instrument is void ab initio and not voidable, it would be Article 65 which would apply to the suit of possession based on title by the plaintiff. Paragraph 22 also. In the last, it was argued that since the alleged possession of the defendant over the suit property can at best be considered to be adverse to the plaintiff from the date of execution of the sale deed dated 14/6/1973 and the suit is filed 1984, that is within 12 years from the date of execution of the implement sale deed, cannot be said to be barred by limitation under Article 65 of the Limitation Act. Number 25, the issue before the Supreme Court. The crux of the issue seems to be whether the Article 65 or Article 59 of the Limitation Act 1963, which would apply in the present facts of the case in hand. The minute thereafter, the minute can now kindly come to page number, number 38. Several authorities have been considered not thereafter. 38. Yeah, please. Concurrent finding of both the first appellate and the High Court indicated that the husband of the defendant, that is one Bhagavat, who had allegedly given the remaining sale consideration of 6,000 during the time of execution of the sale deed, had not stepped into the witness box. Furthermore, one attesting witness to the execution of sale deed, that is Sarpanch, has also died before the deposition could not record. One Buddhu, who was the second witness, attesting witness, was the brother of the defendant, and both the courts had doubted his testimony being partial to the defendant. In all these three, in all, there was no witness that could substantiate the case the defendant and that there was a part payment of the sale consideration at 6,000 during the time of execution of sale deed. Furthermore, no evidence was adduced by the defendant to prove that even the initial amount rupees 9,000 was purportedly paid during the execution of the sale deed was actually received by the plaintiff. Therefore, the argument of the plaintiff in the plaint that she has not received the sale consideration had not been otherwise proven to be false. In such circumstances, that is, in the absence of sale consideration being tendered, the sale deed would be void and the plaintiff would not be required to seek for cancellation. Therefore, Article 59 of the Limitation Act would not be said to be applicable in the present case. Last paragraph 39. The First Appellate Court has rightly observed that the plaintiff has claimed the relief for joint possession. It is also arrived that the finding that the transaction in question is void. To put it simply, in the eyes of law, the plaintiff could not be said to have executed the sale deed. Therefore, the plaintiff could not indeed have maintained an action to obtain possession of the property from the basis of her title, and she filed the same within a period of 12 years from the date of knowledge of the possession of the defendant was adverse to the plaintiff, even if the date of execution of sale deed is 1973 is considered. The suit is filed on 1984, almost 11 years later, will within the penal limitation. Now, Lord, how this applies to me?
Read this para 39 once more.
One second, yes, Lord. The first appellate court has rightly observed that the plaintiff has claimed the relief for joint possession. It has also arrived at a finding that the transaction in question was void. To put it simply, in the eyes of law, the plaintiff could not be said to have executed the sale deed. Therefore, the plaintiff could not indeed have maintained an action to obtain the possession of the property on the basis of her title and filed the same within a period of 12 years from the date of knowledge that the possession of the defendant was adverse to that of plaintiff. Even if the date of execution of the sale deed, that is 14/6/1973, is considered, the suit having been filed on 28/2/1984, that is almost 11 years later, could have been. Now, here in this case, there is a finding that the deed was void. That is the finding.
Where is the finding that
Yes, the trial court.
Appellate.
Appellate court.
You have to assail the finding of the appellate.
Appellate court has not considered that finding. That finding was not challenged.
That finding has been considered. Appellate court is a court of fact and law. Both the things has to be seen by the appellate court. Everything has to be seen by the appellate court.
The appellate court has only discussed about the issue of limitation. Since the deed was executed in May 2007 and I filed the suit in the year 2013, therefore suit is barred by limitation. Not I claim that the deed was void ab initio, and therefore I played for declaration of deed as a null and void. Therefore, my limitation would be covered by Article 65, not by 59 of the limitation. There were 3 years.
Did you seek recovery of possession?
Not I claim for this. My suit is based on title possession.
Did you seek recovery of possession?
No. I am in possession. There is a specific pleading in the plaint that I am in possession of the property. Someone disturbing my possession, therefore, run for proceeding was initiated.
Since when are you in possession?
Lord, after the.
For claiming adverse possession, foundation pleading has to be there.
No, I am not claiming adverse possession.
Should I record that you are not claiming adverse possession?
Lord, it is not my case. It is not my case that I
Not
am.
a case for adverse possession.
Yes, Lord, this is not a case for adverse possession. Lord, I am claiming that my brother has a property, Lord. After his demise, Lord, his widow, Lord, transferred the property beyond the customary law of the godown, Lord. Therefore, Lord, she could not have transferred the property, which the trial court confirmed, Lord, she has no right to transfer. And the same finding has not been challenged by the appellate court. And Lord, the appellate court altogether knew, Lord, the suit is barred by limitation and dismissed the suit appeal again. Therefore, Lord, in my second appeal, Lord, I am putting trying to formulate, Lord, that the issue of limitation, Lord, the limitation on which the Article 59 will apply when I seek for cancellation of deed. Lord, since I do not come up for the cancellation of deed, the limitation would be 12 years. Yes.
Or the learned counsel for the appellant. This has been filed against the judgment and decree dated 20/12/2023. It is acted decree signed on 2/1/2024, that it was passed by the District Judge 1 Lampehar in Civil Appeal number 22 of 2019, whereby the first appeal has been dismissed. The trial court judgment was passed by judgment in decree dated 27/9/2019, it is acted decree signed on 3/10/2019, that it was passed by the Civil Judge Senior Division number 2 Lampehar in title suit number 42 of 2013. The suit was dismissed and the first appeal was also dismissed. Consequently, the appellant The plaintiff is the appellant before this court. The learned counsel for the appellant has referred to the trial court statute and has submitted that specific finding was recorded that the defendant number 1 had no right to execute the sale deed number 2334 of 2007 dated 10/10/2007 in favor of defendant number 2 and the issue number 3 was decided in favor of the plaintiff and against the defendant number 1 and 2. Still the suit was dismissed. The learned counsel submits that this finding was the learned counsel submits that the learned first appellate court has sustained the judgment of dismissal by on the ground that the suit itself was barred by limitation and had applied Article 59 of the Limitation Act the learned counsel submits that the sale deed itself was null and void as the sale was not executed by the plaintiff and the plaintiff was and therefore and since the plaintiff was in possession there was no need to seek any declaration of title by adverse possession. He submits that since the sale deed was not executed by the plaintiff, the suit was to be governed by the provisions of Article 65 of the Limitation Act, and the period of limitation would have been 12 years. He has referred to the judgment passed by Honorable Supreme Court in the case reported in 2011, within bracket 1, bracket close, AIR Jharkhand.
AIR 2005 Supreme Court 4342. Oh, sorry. Sunil Singh. 2011 का
AIR Jharkhand R463 किसका रिपोर्ट है?
AIR रिपोर्ट में
सुप्रीम कोर्ट जजमेंट है ना?
हाँ
2011 within bracket 1 bracket close AIR JHAR R463 passed by Honorable Supreme Court in civil appeal number 2811-2813 of 2010 and has referred to paragraph 6 thereof to submit that when the executant of a deed wants it to be annulled, he has to seek cancellation of the deed, but if a non-executant seeks annulment, then he has to seek a declaration that the deed is invalid or non-honest or illegal and not binding upon him. The learned counsel then relied upon the judgment passed by the Honorable Supreme Court reported in AIA 2005 SC 4342 and as referred to paragraph 5 to give the factual background. In 5, 9, 10 and 11, 9 to 12 to give the factual background of the case and then refer to paragraph 21 and 22, which was the argument advanced on behalf of the appellant,
The original plaintiff.
on behalf of the original plaintiff before the Honorable Supreme Court. And the findings, and has also referred to the findings in paragraph 38 and 39. Which I read under 38 and 39 of the after hearing the learned counsel for the appellant, this court finds that the title suit number 42 of 2013 was filed seeking a declaration that the sailing number 2234 of 2007 dated 10/10/2007 be declared null and void, and for a further declaration that the sanction for the sale deed granted by Deputy Commissioner Land Reforms Lapihar was without jurisdiction, and for a further declaration that the suit land that for the further declaration that if the suit land has again been transferred to defendant number 3 through any registered sale deed, the same be declared null and void. The plaintiff also sought a declaration of title with respect to the suit land. There is no declaration seeking confirmation of possession.
I was in possession, but this is a specific case. I am in possession, para number 9 of my latest statement.
However, there was no relief seeking confirmation of possession with respect to the suit property. बिक्री में ही है आप,
I'm sorry.
आपकी बिक्री में ही है relief हम अभी कर सकते हैं.
Since I am in possession of the specific pleading, will not therefore I answer.
The specific case of the plaintiff was that plot number 475 under khata number 52 the specific case of the plaintiff was that the suit property stood recorded in the name of Mikhail Uram, who died issueless and was survived by his wife, namely defendant number 1, and two sisters of the plaintiffs, and two sisters of the plaintiff. ये कौन है? Defendant number 1 and 2.
Defendant number 1 मतलब वेंडर होगी, उनकी वाइफ.
हाँ.
Defendant number 2 परचेजर होगी. परचेजर जो प्रॉपर्टी इन्होंने 2007 में परचेज किया था.
was survived by his wife, namely defendant number 1, and defendant number 1. Who is defendant number 2?
Purchaser.
And the defendant number 1 had sold the property to defendant number 2. Correct? The plaintiff is the sister of Mikhail. It was the
Number 20 of the appellate judgment, you know, the facts of 20 and 21. Page number 20.
Yes. The specific case of the plaintiff was that, further case of the plaintiff was that following the death of Mikhail Urao, his wife, defendant number 1, sold the suit property by registered sale deed dated 10/10/2007 after taking sanction from the Deputy Commissioner Land Reforms Latehar dated 4/10/2007 regarding which she had no knowledge. His sisters कौन है? Sisters?
मतलब 2 सिस्टर थे मिखाइल की, उसमें से वन ऑफ द सिस्टर इज द प्लेंटिफ, दूसरी मैटर सूट में नहीं आई थी. दोनों अनमैरिड.
As per the plaintiff was a sister of Mikhail Urao, and she had one more sister, namely Susaina Urao, who had expired. However, the plaintiff remained unmarried.
बोथ अनमैरिड.
एक तो डेथ ही हो गया.
हाँ, मतलब उनके पहले भी वो शादी नहीं की.
Death हो गया. It was their further case that parties are governed by the customary law as per Urao tribe. The specific case of the plaintiff was that the defendant number 3 had tried to grab the suit land, and a proceeding was initiated under section 144 CRPC, and it remained inconclusive. The cause of action arose when the sanction for sale of the suit land was accorded on 4/1/2007 and 10/10/2007 when the sale deed was executed. Pursuant to which the plaintiff had no knowledge, and thereafter when she was threatened, the suit was filed. The defendant number 1 and 2 contested the suit by stating that the suit was by taking various technical plea, including the plea that the suit was barred by limitation. It was also asserted that the suit property was originally the Rayati land of Abdul Mia, who was the exclusive owner, and he sold the property through two registered sale deeds. One dated 5/7/1958 and another dated 16/8/1960 for a consideration amount to Mikhail Uram. And thereafter, Mikhail Uram came in possession of the property and got his name mutated. However, Mikhail Uram died leaving behind his wife, the dependent number one, who came in possession and got her name mutated in the government record and was paying rent. It was also asserted that the wife of Mikhail Uram was the owner of the property and the plaintiff had no claim over the suit property. It was also asserted that there was no question for the sisters of Mikhail Uram to share the landed property of Mikhail Uram, and there was no customary law prevailing in the tribal society to share through female. It was also asserted that the defendant number one had sold her own land and was in peaceful possession, and there was no occasion of threat to the plaintiff. And there was no occasion for the plaintiff and others to be in possession of the suit property. The defendant number three had not appeared before the court, and therefore the proceeding was ex parte. The defendant number four was the deputy commissioner, who also did not file his written statement and was ultimately debarred from filing the written statement. The following issues were framed by the learned trial court by order dated 24/8/2017 and 25/9/2019. ये para 4 में है दोनों issues, दो part. The parties led both oral and documentary evidence. Exhibit 1 was the registry slip dated 12/9/2013, and Exhibit 2 was the certified copy of the same deed dated 10/10/2007 / 11/10/2007, executed by defendant number 1 in favor of defendant number 2 for a consideration of rupees 1,39,000. Exhibit A was the original sale deed numbered 2234 dated 11/10/2007. Exhibit B was the rate receipt. Exhibit B series were the rate receipts, and Exhibit C was the certified copy of the registered sale deed number 3624/1960, which was executed in favor of the deceased Mikhail Uram by Kadir Bakshi Mia, and Exhibit CY1 was the registered sale deed number 1918, which was executed in favor of Mikhail Uram by the same person. The the issue number 2 within bracket A was relating to fees. The learned court was of the learned trial court of the view that the plaintiff must deposit the court fees on the valuation of rupees 1,39,000, and it was held that the plaintiff should deposit, that it was necessary to deposit the court fees of the suit land in this suit, and the point was decided against the plaintiff. By deciding issue number 4 regarding the claim of right title, interest and possession over the suit land, the trial court recorded that the trial court recorded finding that, inverted comma, in page 13, as such from perusal of plaintiff witness, it appears that plaintiff has not possessed the suit property, and from perusal of the plaintiff witness, it appears that plaintiff claimed her ancestral property of suit land. From perusal of exhibit C and C by 1, it appears that Mrs. Mikhail Rao had purchased suit land from Abdul Qadir Baksh Mia. Defendant number 1, Norbela Dispota, also admitted aforesaid fact in his deposition. Defendant number 1 from here. Let me quotation as such, many contradictions available on plaintiff's witness. Therefore, they have confused that the suit property is ancestral property or self-acquired property of deceased Michael Rao. Sanction order of the aforesaid sale deed has not been proved or produced on behalf of the plaintiff. Plaintiff neither filed notice under section 80 CPC nor proved the aforesaid notice under section 80 CPC before the court. करिए और इन्वर्टेड कॉमा बंद. इसके बाद देखिए further inverted comma, on the basis of the aforesaid facts and circumstances, plaintiff failed to prove her right title, interest and possession over the suit land. Therefore, issue number 4 is decided against the plaintiff and in favor of the defendants. Inverted comma close. By deciding issue number 3, the learned trial court recorded that it appeared that defendant number 1 executed the sale deed in favor of defendant number 2 after receiving consideration amount, and the suit property was self-acquired property of deceased Mikhail Rao. After death of Mikhail Rao, his wife, defendant number 1, succeeded the aforesaid property and acquired right title, interest and possession over the suit property. Later on, she executed sale deed exhibit 1 by A. And as such, due to being self-acquired property of deceased Mikhail Rao, his widow acquired right title and interest and possession over the suit land. Therefore, he had the right to execute the aforesaid sale deed, that is exhibit 1 by A, in favor of defendant number 2, namely Norbela. Further, the learned court recorded that it was admitted that both the parties are tribal communities. The witnesses have established that they are governed by tribal custom. Any woman of Oraon community has only limited right for maintenance of any property in tribal custom, and recorded that the learned counsel for the defendant number 1 and 2 failed to file or produce any provision or citation that self-required property is not covered or governed by tribal community, and lady has full right, title and interest over the self-required property in tribal community. And on this basis, the learned trial court held that defendant number 1 had no right to execute say deed dated 10/10/2007 in favor of defendant number 2, and the issue number 3 was ultimately decided in favor of the plaintiff and against the defendant number 1. The trial court thereafter disposed of issue number 1 and 2 and held that since the finding was in view of the discussions in connection with issue number 2 with bracket A and issue number 4, the suit was not maintainable in the present form, and issue number 1 and 2 were decided against the plaintiff. And issue number 5 was decided by holding that the plaintiff is not entitled to any relief, and ultimately the suit was dismissed. So far as the learned first appellate court is concerned, the points for determination were as under point number 1, para 13, whether the suit is barred by law of limitation. Point number 2, whether the findings recorded by the learned trial court is correct or deserves interference. The learned The perusal of the judgment of the learned first appellate court reveals that arguments were also advanced on the point of limitation, though the learned trial court did not frame any specific issue on the point of limitation, but the defendant in the written statement had raised the plea of the suit being barred by limitation. While considering the point number 1, the learned first appellate court observed that it is the duty of, in paragraph 17 of the judgment, that it is the duty of the court to see as to whether suit has been filed within the period of limitation. But the court exercised power under Order 49, Rule 33, and observed that the state provision empowers the appellate court to exercise all powers. The learned first appellate court recorded the findings in connection with, discussed the materials on record and recorded the findings and recorded in paragraph 20 and 21 as under. Thereafter, the learned court considered other materials or oral evidence of the respective parties. The learned appellate court also the learned court ultimately in paragraph 24 and 25 held that the suit was barred by limitation by referring to Article 59 of the Limitation Act. The findings are as under. The learned first appellate court thereafter took up the second point for determination from paragraph 26 onwards, which was relatable to from paragraph 26 onwards. And observe that as per Hindu Succession Act, as per the provision, Hindu Succession Act is not applicable to tribal community. And observe that the learned trial court had put reliance that both the parties belong to tribal community and customs give only limited right of maintenance from any property, but the pleadings were silent on this score. Para 29. The learned first appellate court then referred to the judgment passed by the Honorable Supreme Court in the case of Lakshmi Bai versus Bhagwan Goa, reported in bracket 2013, bracket 24 SCC 97. Wherein it has been held that the custom is required to be pleaded and proved. And the person and the party concerned must prove there is custom. The learned court also it has also been held that material custom must be proved properly and satisfactorily. Until the time that such custom has by way of frequent proof in the court becomes so notorious that the court takes judicial notice of the same. The learned court thereafter also took into consideration the judgment passed by this court in the case of Prabha Mills versus Martha Ekka, reported in 2022 to CUR CC 327, wherein it has been observed that in every case of claim of title, there has to be decided on customary law. It has to be pleaded. Customary law is required to be pleaded and proved regarding the prevailing custom. The learned court thereafter referred to the judgment passed by the Honorable Supreme Court in the case of Subasco Luis Fernandez versus KPB Shastri, reported in 2014, that it was 1 JJR 300 SC, wherein it has been held that in title suit the plaintiff has to establish his claim of ownership, and the onus and the initial onus is always on the plaintiff. The learned appellate court thereafter held in paragraph 40 that the plaintiff had to prove customary rights strictly as per section 48 of the Indian Evidence Act. The court recorded that the pleadings oral from the pleadings oral and documentary evidences adduced on behalf of the plaintiff failed to plead and prove the general binding custom amongst the Oraon tribal that females were excluded from inheritance. The pleading and evidence of the plaintiff did not qualify the essentials to prove customary right. Since the custom was to be proved by oral and other evidences, and the court found that there was lack of sufficient pleading and evidence on the point of custom by the plaintiff, and ultimately held that the finding of the trial court that the defendant number 1 had no right to execute CAD number 2334 of 2007 dated 10/10/2007 in favor of defendant number 2 as per customary law of succession applicable to the tribal warrants interference. The findings of the learned first appellate court in paragraph 40 to 43 is quoted as under. This court finds that the learned first appellate court has given a clear finding that the plaintiff has failed to plead and prove the customs by which the defendant was debarred from executing the sale. The fact remains that defendant number 1 was the wife of Mikhail Uran, who had purchased the property admittedly from non-tribal, who had purchased the property, and the courts have recorded a finding that it was his self-acquired property, and it was upon death his wife had sold the property after due permission from the competent authority, and the plaintiff, being the sister of Mikhail Uran, was challenging the sale deed. This court finds that the first appellate court has dismissed the appeal not only on the point of limitation but also on merits by holding that the finding of the trial court that the defendant number 1 had no right to execute the sale deed dated 10/10/2007 in favor of the defendant number 2, which was under challenge in the suit called for interference. So far as the point of limitation is concerned, as argued by the learned counsel for the appellant, this court finds that though the plaintiff had sought a declaration that the sale deed executed by defendant number 1 in favor of defendant number 2 was void, but the plaintiff has failed to prove that, primarily on the ground that the defendant number 1 had no right to sell the property, which the plaintiff has failed to prove. This court finds that in the judgment, this court also finds that this court finds that in the judgment passed by the Honorable Supreme Court included in AIR 2025 SC 4342 Sutra, it was alleged that the CNT involved in the same case was fraudulently executed and was void as the CNT itself was in connection with the share of the plaintiff, and therefore the vendor had no right to execute the CNT. The it was also held that the CNT, it was without consideration. The CNT itself was null and void as the CNT was fully without consideration. And it was the specific case of the plaintiff that no consideration was passed in connection with the CNT which was under challenge. It was in this background, the Honorable Supreme Court was of the view that even if the deed was executed, the action could have been maintained by the plaintiff to obtain the possession of the property, which could have been filed within a period of 12 years. In the present case, the plaintiff is not seeking possession of the property, and the rent receipts were filed by the defendants and not by the plaintiff.
B series.
Sorry?
B series.
Reasons. And there was, this court finds that merely because the plaintiff was not the executant of the CND and had sought a declaration that the CND was void, the same itself is not sufficient to hold that, to say that the suit would be governed by Article 65 and not by Article 59 of the Limitation Act. In this regard, a reference is required to be made to the judgment passed by Honorable Supreme Court in the case of Prem Singh versus B.
Referred as.
So,
Referred as.
referred as. Prem Singh versus Bilwal reported in Rapid 2006, Rapid Close 5 SCC 350.
Page number 29.
This court is of the considered view that, this court is of the considered view, in para 29, इसको quote कर देंगे 25 वाले जगह से. This court is of the considered view that the present suit was certainly governed by Article 59 and not by Article 65, and no substantial question, and this aspect of the matter that the suit would be governed by Article 59 has been duly considered by the learned First Appellate Court. Considering the opposite aspects of the matter, this court finds no substantial question of law involved in this case. With upper limitation, yes.
Yes, 94 members.
ID number 6695 of 24 has been filed seeking condonation of delay of 95 days in filing this appeal. And the only ground which has been taken
Para number 5.
is
Mr.
that the appellant is a poor illiterate lady, and due to poverty, she could not raise the required money for filing the second claim. This court has considered the merits of the case and has found that there is no substantial question of law. And otherwise also this court is not satisfied with the cause shown by the appellant seeking confirmation of the accordingly or early in the second.
Against the finding of the trial court one issue, no appeal has been preferred. Against issue number 3.
The learned counsel submits that against the finding of the learned trial court, no separate appeal was preferred by the defendant. इसके बारे में
Issue number 3.
The appellate court's judgment revealed that the parties had advanced their arguments with respect to all the issues which were raised before the learned trial. And the court, learned first appellate court, being a question of fact as well as law, has considered all the aspects.
Declare.
Under heading for hearing under Order 41 Rule 11, Item 66, Second Appeal 191 of 2025.
No adjournment slip has been circulated. I will not grant you time without cost.
This was the argument by senior counsel and we prepared the case also, the arguments, but he fell ill also in the morning also. That was the
You argue your case. I will not grant you for you.
any day.
Any day tomorrow. What do you do? Any day. Who is your counsel?
Look at Salish.
You argue your case. Or I will impose cost. I will not adjourn your case.
Any day next week. Next week, Monday or Tuesday, will be valued also.
Essay number 191 of 2025. Mr. Nambatari,
Abhijit
Mr. Abhijit Kumar
Say.
Singh, advocate, seeks adjournment by saying that this case has to be argued by Mr. Sailesh Kumar Singh, and he submits that for personal reasons he is not available today. At his request, the matter is directed to be posted on Monday to be taken up as first case as to 15. It is made clear that sorry?
Tuesday also.
Tuesday को तो last day है, last working day नहीं है।
First.
आपने मंडे बोला ना, मैंने मंडे कर दिया। अब ट्यूसडे why are you giving it a second thought? Right? Monday second half आप आ जाइए। It is made clear that no further adjournment will be granted. First case of the day.
Item 67, Second Appeal 193 of 2025.
Under some capacity today, so my on the last date when this was taken up on 8th of December, I had sought adjournment so that the additional I wanted to argue substantial question of law which was not there in memo of appeal. So I have filed an IA for additional substantial question of law. In the meantime, what has happened in leadership? My brief has been misplaced. I got a photocopy from my client, but trial court judgment is not legible. I have got the appellate court judgment from the key court service.
You can't have an argument of I have adjourned the matter on cost, you also pay cost. Because you see, we have to maintain.
I understand, therefore I was
It does not
from,
look nice that for one
I
council I grant time, for other I can do this. So you can have any number of persons in this. I can give you time, but you pay some cost. So you pay cost to the advocate, this advocate clerk, and it anyway.
there are two requests. First, your lady should kindly ask the court master or the registry to provide you soft copy of the market.
Sure, yeah.
And
What else?
and on reopening the 5th or 6th.
Essay number 193 of 2020. Learned counsel for the applicant is present. Seeks adjournment. No advance notice has been circulated for adjournment in this case. However, at his request, the matter is adjourned and is directed to be posted on 6th of January 2026. Subject to payment of cost of ₹5,000 for Advocate Clerk Association and the receipt regarding payment of cost should be deposited by 5th of January. Failing this, the appeal shall stand dismissed without reference to payment. At this, the learned counsel for the appellant has requested for a soft copy of the entire records of this case. Office is directed to provide the same at his following email. Wait.